Namaste friends, welcome to my channel. This is your Govindraj here. Thank you for all your views and also comments and sharing my videos to all your contacts. And today let me give you a quick update on the recent Karnataka government ordinance on amending certain labor laws, basically Industrial Dispute Act and Factories Act and also Contract Labor Act. And we will look into certain details and also we will discuss how this is going to benefit the employers in the days ahead. So let's proceed friends. This is the ordinance which recently promulgated by the Honorable Governor of Karnataka on 31st July 2020. And as per this, certain provisions related to applicability in Industrial Dispute Act 1947, Factories Act 1948, and Contract Labor Regulation and Abolition Act 1970 are amended through executive legislation, or which is called an ordinance. So before we proceed on this topic, we need to know what are the limitations of executive legislations, because it is not by way of regular route of lawmaking. So it is an ordinance and not by way of regular lawmaking route, as I told you already. And the regular lawmaking route is Legislative Assembly and Legislative Council. See, the Honorable Governor has promulgated this ordinance using his discretion and also on the aid and advice of the Council of Ministers, which is Cabinet, under Article 213 of the Constitution of India, considering the current circumstances which need immediate action while both the houses of legislature are not in session. And if you look at this ordinance, the maximum life of any ordinance could be around 6 weeks plus 6 months. So if at all, if the government wants to make this permanent, the government should bring a bill to replace the ordinance and make corresponding changes in the respective legislations, which are basically in our case Industrial Dispute Act, Factories Act and Contract Labor Act in our case, as I said. And if this is not done, it is only a temporary relief or measure for employers for which they need to be happy. So therefore, it is important that the government brings amendment by way of bill, introducing in the assembly as well as the council, and bring respective changes into the corresponding acts, which is ID Act, Contract Labor Regulation and Abolition Act, and also the Factories Act. And the state is empowered to do so, because the subject matter is placed in the concurrent list of our constitution. So there is some procedure involved, and I am sure the government is going to make this permanent by way of bringing legislative changes to the respective acts. And now let's understand the details of the ordinance, and also which are brought certain amendments. So first amendment which I am going to talk about is, which is there also in the ordinance, which is about Industrial Dispute Act 1947. As I said, there are certain provisions which are related to applicability of certain key provisions are amended. So first thing, if you look at amendment to the Industrial Dispute Act 1947, section 25K, both subsection 1 and subsection 1A are amended. So let's discuss first subsection 1. See, as per subsection 1 of 25K in chapter 5B, these are special provisions, and it is a special chapter applicable for a factory, mine and plantation, and it contains certain restrictions on layoff, retrenchment and closure. And if you look at what is the importance of section 25K is, see, it explains the applicability of this chapter to a factory, mine and plantation, and which also says that the special provisions are applicable in which not less than 100 workmen were employed on any average day for the preceding 12 months. So therefore, it is important to know how this is going to impact the employer. And establishment covered under this chapter cannot lay off, retrench or close down without having the permission from the appropriate government, as per chapter 5B and as per this section 25K. And moreover, if you look at the restrictions, 3 months notice or pay in lieu of this notice is necessary in case of retrenchment for those who are covered under chapter 5B. Whereas if you look at chapter 5A, this is 1 month notice or pay in lieu of this notice is sufficient. And now, because of this ordinance, because of this amendment, the restrictions or special provisions are not applicable to factory, mine or plantation having less than 300 workmen. Now, I also told you there is another amendment, which is subsection 1A. See, this subsection 1A of 25K is also amended as per this ordinance. So the state government currently without this amendment, can apply the provisions of section 25O and 25R. These are related to closure of industrial establishment. And now subsection 1A of chapter 5B, the state government can apply these provisions also to seasonal establishment having workmen not less than 100. So there is a possibility. Now now because of this amendment, now this limit also is enhanced to not less than 300. So that is the amendment which is brought on Industrial Dispute Act. However, it does not mean that, friends, you can resort to these provisions without having valid and genuine reasons, because there are instances or disputes where the action of the employer is held as not justified. So therefore, definitely a caution is necessary. And moreover, you are required to follow the provisions under chapter 5A on this matter, especially layoff, retrenchment, closure, and other few of the provisions. Now, on layoff and retrenchment, I already have 2 more videos which talks about in detail provisions which are helpful to managers, employers, and also who are involved in this profession. If you are interested, you can also go to my channel and also watch these videos for better understanding of the provisions. Now let me come to another important amendment which is as per the ordinance, which is related to Factories Act 1948. See, here you can see 2 amendments. One is which is related to definition of factory, and another one which is related to section 65 of the Factories Act, which is related to exempting orders. So we will talk about these things little detail also. Let me come to the first amendment. Now, if you look at section 2M, it defines what is a factory. So what is the current situation is, before the amendment, where 10 or more workers and where manufacturing is carried out with the aid of power, then it is a factory. And in case where 20 or more workers and there is a manufacturing process and without the aid of power, then it is a factory. Now because of this amendment, these limits are enhanced to 20 or more in the first case and 40 or more in the second case. Now, what is this implication? This means many more small factories are going away from the provisions of Factories Act 1948, and including of course registration and licensing. There are certain provisions which are related to safety, health, working conditions, leaves, everything, and also of course registration and licensing. The small factories which are coming under these limits will not be in the Factories Act purview. Now another question comes to my mind is, because of this change, do these exempted factories come under Karnataka Shops and Commercial Establishments Act 1961 for licensing and other working condition provisions? So this is also important to deliberate a little bit. And if you look at section 2E and section 2E U of the Karnataka Shops and Establishments Act 1961, so this while by reading these definitions, you get some kind of where there is a trading or business element, and also this as per section 2E of commercial establishment definition, the state government can also include any establishment as a commercial establishment or shop by a way of a notification and declare it to be a commercial establishment for the purpose of this act. And if you look at section 2U of shop, it also give you an element of any trade or business is carried on or where services are rendered to customer. So because of this definition, in my view, as long as the trade or element of business exists in such factories, they get covered under the Shops and Commercial Establishment Act, if the area is included in the schedule to the act or notified for coverage. See, because if you look at Shops and Establishments Act 1961, the coverage is not automatic to every area. There is a schedule, and if the area is listed in the schedule or by way of notification, the Government of Karnataka has brought that area into coverage, then only Shops and Establishment Act 1961 is going to cover. So therefore, it is important that if the industry is in a covered area, then this can be also covered under Shops and Establishment Act. So I will also give you another comparative study. I looked at the Maharashtra Shops and Establishment, which is Regulation of Employment and Conditions of Service Act 2017, which came into effect in December 2017. And as per section 2.4, the definition of establishment is given. See, this definition of establishment also covers any business, trade or profession or work in connection with or incidental or auxiliary thereto, and includes shop, residential hotel, restaurant, eating house, theatre, or other place of public amusement or entertainment, and also to whom the provisions of the Factories Act 1948 does not apply. So this is very clear. Where the provisions of the Factories Act are not applicable, then it is classified as an establishment. So therefore, in our case also, it is good if the government specifically covers such factories by a notification or amendment to the definitions for clarity and future implementation purpose. So otherwise, if there is no clarity, then these exempted factories will become the area of no man's land. Now let's get into another amendment which is related to exempting orders as per section 65. See, as per section 65, especially say under section 65(2), the director or chief inspector of factories can exempt any factory from the provisions of section 51, 52, 54 and 56 if the employer has got exceptional pressure of work. However, for these limits, the outer limits are also provided. Any exemption is given, so also has to meet these outer limits as per subsection 65(3). And if you look at section 51, 52, 54 and 56, section 51 talks about weekly hours, section 52 talks about weekly holidays, and section 54 talks about daily hours, and section 56 talks about spread over. So there are certain limits which are need to adhere even if they get exemption. And if you look at the Factories Act, the overtime is regulated under the Factories Act, and it is not allowed to do overtime without the express permission other than essential and emergency works as allowed under rule 116 of the Karnataka Factories Rules 1969. So this rules talks about certain exemptions, and of course there are certain outer limits also for these exemptions. So other than this, and nobody is allowed to take overtime without the express permission from the authorities. Now, the current overtime limit per quarter is 75 hours. However, this 75 hours is subject to adherence to limits on daily and weekly hours. There are certain riders on this. The employer is required to know and also follow this. Now, this 75 hours is limit is enhanced to 125 hours by way of this amendment. If you would like to know more about the working hours ceiling and also overtime ceiling on a daily, weekly, monthly and quarterly basis, this is my video. You can also visit my channel and watch this video for more details on this. And however, because of this change, it may be noted that friends, there is no exemption from the permissions. You are still required to take permission from the authorities to do overtime for up to 125 hours. And also, overtime cannot be taken from women employees because there are restrictions placed under section 66, and also there is no exemption from double wages for overtime work. So you are required to still pay twice the rate of the wages for any overtime you take. Now let's come to the final amendment, which is amendments to Contract Labor Regulation and Abolition Act 1970, and basically section 14A or subsection class A of subsection 4 of 1 is amended to with regard to applicability of Contract Labor Regulation and Abolition Act 1970. See, currently the CLRA Act 1970 applies for principal employer or establishment if he has 20 or more contract laborers. Now this applicability is changed to 50 or more contract employees. This means employer having up to 49 contract employees are not required to register and comply the other provisions of Contract Labor Abolition Act Regulation and Abolition Act 1970. See, however, it should be noted that friends, section 14B or class B of subsection 4 of 1 talks about the applicability for contractor. So now this provision is not amended. Therefore, the contractor is still the contractor who is having 20 or more contract workers is still required to comply the provisions, including licensing. Government also want to protect the interest of contract workers of these exempted establishments. So therefore, it is deliberately not amended also. This could be this reason also. Now let's briefly discuss how does this benefit the employers. See, if you look at Contract Labor Regulation and Abolition Act, there is no express bar or prohibition to employ contract labor in any kind of work, including continuous or perennial nature of jobs, unless there is any prohibition by the appropriate government to employ contract labor in any process, operation or other work in any establishment, however subject to the provisions under section 10 of the act. This section 10 talks about certain criteria before the government decides to prohibit the employment of contract labor. However, if you look at how today it is administered, there is an executive imposed restriction on works which are allowed to employ contract labor. So it's not easy that you get permission to employ contract labor in your registration certificate and license in the contractor license. So now the establishment which engage 49 and below contract employees are not required to worry about these registrations and other things, and also these important hassles. So therefore, this is going to benefit certain small and medium segment employees who employ certain minimum number of contract employees. So far friends, I talked about these amendments. Thank you very much friends for watching my video so far, and if you like this effort, please do share, subscribe, and also put your comments in the comment box, and also don't forget to like, and please permit me to sign off now. I will come back with new videos and new information. Stay safe, and thank you very much friends.